My name is Ken Tassif, and I'm the Compliance Program Manager for the San Luis Obispo County Health Agency. This training is intended to address the agency's obligation to train on topics related to privacy and security of health information. But as you go through the training today, I'd like to ask you to think about how the concepts you learn apply to all of the confidential information you encounter in your job. This training should take about an hour. Much of the training will involve a discussion of the different elements of health information privacy and security regulations, focusing on our procedures and your role in ensuring that we are in compliance with regulations. There will be a few questions scattered throughout the training that are intended to reinforce a concept or pique your interest. You'll have to click to advance past these question slides, and they are not scored. You'll see navigation buttons on the bottom of the screen. These are standard navigation buttons that allow you to move back in the training, but you can't move forward. You'll have to go through each of the slides. The table of contents will also let you navigate through the slides that you have already listened to. If you can't finish the training in one sitting, Relias training software will remember where you stopped your session and will restart at the beginning of the same slide when you return. At the end of the training, you'll have a final question that requires you to attest to the completion of the training and commit to the confidentiality and security of our health information. As employees of the health agency, we're entrusted to protect the information we work with. In your job, you may come into contact with client health information, other personal information about clients, financial information, and information related to the health agency that should just stay confidential. It's critical that you protect any confidential information that you use or come into contact with. In addition, you must take reasonable steps to ensure that the confidential information that you do receive, regardless of its format, is protected from theft or inadvertent access. It's not only the law and our policy, it's also a condition of employment. Our collective effort to ensure the privacy and security of confidential information upholds our core values, it demonstrates respect for our clients, and it supports compliance with state and federal laws. Your commitment to protecting client health information will ensure our success as an agency and the confidence our clients place in us. The objectives of this training are to help you understand the basics of health information privacy laws and the health agency's policies supporting those laws. We'll discuss what our clients' rights are under the law, what health information the health agency is allowed to use or disclose, and who may use or disclose it. We'll also discuss your obligation to safeguard client information and let you know some of the consequences for not complying with the law or our policies. First, let's talk about the laws that govern health information privacy. When we think of health information privacy, most of us initially think of the Health Insurance Portability and Accountability Act, also known as HIPAA. While that's fine, it's important to understand that there are many other laws governing the use and disclosure of health information. Some of these include the California Welfare and Institutions Code, sections 5328 through 5330, which regulate what mental health information is allowed to be disclosed. There's also Title 42 CFR Part 2 of the Code of Federal Regulation that tightly restricts the use or disclosure of drug and alcohol client information. There's the California Medical Information Act, or CMIA, which was California's precursor to HIPAA, and there are various health and safety codes that discuss what we need to do if we improperly use or disclose a client's health information. In addition to the various laws, we also have contracts with state agencies that add requirements which the health agency must comply. For example, this training complies with our contracts that require the health agency to provide privacy and security training annually. Together, these laws set standards for how a covered entity, that is, a person or organization that must comply with the laws, has to maintain the privacy and security of confidential health information. You might ask, what's the difference between privacy and security? It'll be more apparent as we go through this training. However, privacy can be best described as following the policies and laws governing how you use or disclose confidential health information. Examples of privacy include not looking at information that you don't have a job-related reason to see, or not talking about client issues with others who don't have a need to know. Security, on the other hand, is best described as safeguarding confidential information in a way that prevents others from inappropriately accessing it, or in a way that prevents improper disclosures. Examples of this include locking your workstation when you're away, shredding confidential documents when they are no longer needed, and ensuring that others can't see confidential information on your computer screens. These laws also set standards for our obligation to notify the client if their health information is used or disclosed in a way that's not allowed by the regulations. Improper disclosure of health information is also known as a breach. Lastly, the genesis of these laws comes from the fact that the federal government was trying to move the medical community towards using electronic medical records. Recognizing that there are inherent risks in transmitting records electronically, these laws set standards for how confidential information can be transmitted. So you might ask, why not just have one law? This is not so easy to answer. However, one reason is that some laws were adopted before others. For example, the California Medical Information Act was adopted prior to HIPAA. It has some elements that are more restrictive than HIPAA, and the state decided to leave it in place. HIPAA regulations allow stricter state privacy laws to supersede the federal regulations. So HIPAA sets the minimum standard for privacy and security clients, but we must comply with the most strict of the state or federal laws. The important thing to know is that all of these laws work together to safeguard our clients' protected health information, which is commonly known as PHI. I'll use that acronym, again PHI, throughout the rest of this training. What is PHI? Well, PHI is protected health information in any form that identifies an individual and relates to their past, present, or future health condition. It may also relate to the health care they are receiving or to payment or reimbursement for health care provided. It's important to remember that in order for health information to be PHI or protected health information, it must have something that identifies the client attached to the health information. We'll go over what information identifies a client shortly. ePHI is a subset of PHI. ePHI, or electronic PHI, is simply protected health information that's in electronic form. It includes health information stored in a computer database such as Anastasia, health information stored on your computer, or health information stored in a network drive such as the P drive, M drive, or S drive. ePHI is also health information sent or received via email or fax, and ePHI can be accessed or stored on a mobile device such as a laptop, tablet, smartphone, flash drive, compact disc, or other portable media. ePHI can be especially vulnerable because a breach can result in the improper disclosure of information for large numbers of clients. The biggest health information breaches have all been involving ePHI. For example, a company named AvMed in Miami lost the names, addresses, social security numbers, and medical information of 1.2 million clients when 2 unencrypted laptops were stolen. Another example was the Utah Department of Health losing 780,000 similar records when a hacker stole information after an employee loaded unauthorized software containing malicious code that gave the hacker access. Now you may ask, who's subject to these laws? The answer is pretty much any entity that provides healthcare treatment services, such as doctors, hospitals, or healthcare agencies. In addition, any entity that supports a treatment provider that receives PHI is subject to these laws as well. These include labs, pharmacies, billing agencies, insurance companies, regulatory agencies, licensing agencies, and accreditation agencies. Does this include you? The answer is yes. Most employees of the health agency must comply with these laws because they either use PHI as part of their job or they're in reasonable proximity and need to understand the laws in case they're exposed to PHI. Exceptions in the health agency include the Animal Services Division, the Environmental Health Division, and the Public Guardian's Office. Animal Services and Environmental Health simply don't work with PHI and don't have a reasonable risk exposure, while the Public Guardian's Office has special authorization through the courts. So if you work with PHI, it's important for you to know the health agency's policies and laws so you can be sure to protect our clients' privacy. And if you don't normally work with PHI, you'll know what to do if you inadvertently find or access PHI. So if you work with PHI, it's important for you to know the health agency's policies and the various laws so that you can be sure to protect our clients' privacy. If you don't work with PHI, you'll still know what to do if you inadvertently find or access PHI. As I said earlier, our contracts with the state require us to do training annually, but you can expect to see reminders throughout the year. While the laws can be very complex, unless you're a treatment professional, supervisor, or health information technician, following the county's policies will be sufficient to ensure compliance with the law. The important thing to remember for all health agency employees is to follow our policy. Links to the privacy and security policies will be provided at the end of this training. Treatment professionals, supervisors, and health information technicians will continue to receive advanced training on privacy, use, and disclosure of health information. The various laws generally focus on 5 areas. They are privacy of protected health information, clients' rights regarding their PHI, security of PHI and electronic PHI, breach handling and notification, in other words, what an agency must do when there's an unpermitted use or disclosure, and lastly, workforce obligations, which include our obligation to analyze where we have risk, address the risk within policy or technology, train our employees, and discipline if the policy or law is not followed. We'll go through each of these in detail. Let's start with privacy of protected health information, or PHI. Remember that we define PHI as any information about health status, provision of health care, or payment for health care that can be linked to a specific individual. This is interpreted rather broadly and includes any part of a patient's medical record or payment history. What do we mean by information linked to a specific individual or that can identify a client? Well, the law recognizes 18 identifiers that make generic health information into protected health information. I'll show you these on the next slide. PHI can be in a client's medical records, billing records, sign-in sheets, attendance records, referrals, appointments, anywhere a client can be identified as receiving treatment or participating in a program. Also, PHI can be in any form. We all understand that paper medical records can be PHI, and most of us understand that electronic software such as Anasazi stores PHI, but we need to understand also that other formats such as emails, texts, faxes, scans, screen captures, and your personal memory also hold PHI. I mentioned that there are 18 identifiers that, when coupled with health information, transform it into protected health information. Now, technically, without one of these identifiers, the information is not protected. However, even acknowledging that a person is a client with a program at the health agency may be a disclosure of PHI, so we must be very, very careful about how we disclose any information about a client. Having one of these identifiers coupled with health information is not necessarily a problem. It just means that we must handle the information as protected health information and follow health agency policy and the law when using or disclosing it. So what exactly do we mean by privacy of PHI? Earlier I said that privacy can be best described as following policies and laws governing how you use or disclose confidential health information. Examples of privacy include not looking at information that you don't have a job-related reason to see, or not talking about client issues with others who don't have a need to know. For those of you who need to share information with others on a treatment team or to discuss a job-related client issue with your supervisor, the law allows those discussions. There are numerous other reasons you may share or disclose PHI. The important thing to remember is that you must only share protected client information with those with a job-related need to know. Also, when discussing PHI with the treatment team, you need to be aware of your surroundings. Ensure that others who do not have a need to know can't overhear your conversation, for example. At times you may see someone who you know come in for treatment, and it's important that you not approach that person about their participation in a health agency program unless it's in the course of your job. In addition, you must never discuss the fact that the person applied for or participated in a health agency program with anyone else not directly involved in their care. Violating these principles can result in some of the most common types of breaches. You must also never peek into the record of a client or access any information about the client unless you're authorized and have a job-related need to do so. Checking the medical records of friends, relatives, or others such as politicians or celebrities is one of the most serious breaches. The bottom line is that you must never access, use, or disclose a client's protected health information unless you are authorized to do so and have a job-related reason. While we want to ensure that a client's PHI remains confidential, these laws were not created to stop us from providing care to our clients or doing our jobs. We can still access, use, and disclose PHI so that we can treat our clients, operate the health agency, and bill or reimburse for services. This use of PHI for treatment, payment, and operations is commonly known as TPO. The law specifically allows us to use PHI for TPO purposes. The most common use of PHI is when we share PHI between qualified professionals within the health agency who are directly treating the client. This may be communication within one of our divisions, or it may include sharing information between several divisions, such as sharing between mental health professionals and public health professionals. We commonly see this collaboration during treatment of inmates at the jail, for example. Treatment professionals in mental health and alcohol and drug services also regularly collaborate and share PHI for clients who have co-occurring disorders. We generally consider TEMA, Family Care Network, Sober Schools, the Kinship Center, and Child Development Resource Centers to be the same as other communication within the health agency. However, communication with other agencies outside of the health agency would be a special disclosure. We also use PHI within the health agency to process requests for payment or reimbursements, where the PHI must go to the agency making the payment. In these cases, we only send the minimum information necessary to comply with the reimbursement requirements. Lastly, we use PHI for health agency operations. These include public health monitoring, internal quality assurance, process improvements, and other operational needs. As I showed you before, in the Policy and Procedures document, we have a matrix that gives employees guidance on what may be disclosed depending on your classification and the division you work in. For example, treatment professionals in drug and alcohol services will have different disclosure standards than treatment professionals in public health. This is primarily due to differences in the laws for the different programs. While this list does not contemplate every type of disclosure situation you might encounter, it does provide you with standards so that you'll know what disclosures you may or may not make. The important thing to remember is to consult with your supervisor or a custodian of records if you're unsure whether you're authorized to make a disclosure. Much like the guidelines for treatment professionals, support staff and custodian of records also have guidelines for disclosure of medical information. The left-hand margin of the matrix showing classifications will help you know your limits on disclosure. However, any employee can be designated as a custodian of records. Remember that a custodian of records may have broad latitude for disclosure or may only be authorized by their supervisor to disclose limited information. Those limits will be communicated to the custodian of records in writing. While we're allowed to use and disclose PHI to care for and treat clients, the law requires that organizations take reasonable steps to allow access only to the minimum PHI necessary to perform a specific task or job. This minimum necessary standard applies to both internal uses as well as external disclosures. Employees and external providers must only receive information tailored to the specific task or job. It's important that you do not access, use, or disclose more confidential information than you're authorized and need to complete your job. The minimum necessary standard is not intended to impede client care and therefore does not apply to qualified professionals involved in the direct care and treatment of the client. Direct care team members may share any PHI they feel is necessary for client care. Nonetheless, a conservative approach is always advised. If you're authorized to discuss or share protected health information about a client, it's important that you know and understand the laws and policies regulating the disclosure. You must know when you may or may not discuss PHI. You must take reasonable precautions to verify that the person you're speaking with is also authorized to discuss a client's PHI, and you must ensure that your discussions can't be overheard by others. Lastly, you must log the disclosure in the client's health records in compliance with the health agency's policy on logging disclosures. Let's talk about the consequences of not complying with the law or with health agency policy. We'll start with penalties for unpermitted disclosures or breaches. Remember earlier I told you about the breach by AvMed? That breach ended up costing AvMed a settlement of $3 million. The Utah Department of Health got off a bit easier. They had to offer the 780,000 clients credit monitoring for a year, costing them about $2 million. The bottom line is that the U.S. Department of Health and Human Services doesn't have the staff to audit everyone. They depend on agencies and businesses to comply because it's the law. They encourage compliance by levying hefty fines on those who violate the law. It's called deterrence, and it generally works. Besides fines and sanctions against an agency, the Office for Civil Rights, the Division of Health and Human Services that enforces these privacy laws, can fine an individual if the violation was intentional or negligent. These fines can be minor or can be as high as $10,000 per violation. In addition, if a breach is found to be malicious or criminal, the Office for Civil Rights can prosecute the individual or an officer of a company. Lastly, HIPAA law says that a covered entity must discipline employees for not complying with policies or laws. It does not say how that has to happen, but at the county we have a progressive discipline system governed by the civil service rules. Our goal is compliance, not discipline. The takeaway here, though, is to remember that there can be serious consequences for not complying with the law or with health agency policy. Many of you are already trained on privacy and security of information related to your job. However, some of you may be asking, how do I know what applies to my specific job? Well, your supervisor should be able to give you guidance on issues related to the privacy and security of PHI. If you're unsure about an issue regarding health information privacy and security, be sure to ask your supervisor or a manager. If they don't have an answer, they'll get one for you. Let's talk through some situations we may encounter in our job and discuss how policy says we need to respond. Let's say I work in the drug and alcohol division and a friend told me that her sister's been very depressed lately and she's worried. She saw her sister's car at the outpatient parking lot and is asking me to check the system and see if her sister is being seen so that she can support her through this difficult time. Now, I'd like to help my friend out, but what does our policy say I can do? Well, our policy says that you may only access the information if it's necessary for you to do your job, and you may only access the minimum necessary information to complete the task. In this case, you don't have a business need to see the health information. You must not access the record at all. But say you're part of the treatment team and you have already seen the records and you know information about the client. Then you should not even acknowledge that the sister may be in treatment. In a case like this, you should advise your supervisor about your friend's request and let your supervisor know that you are taking no action on behalf of your friend. Your supervisor will give you guidance in this matter. Here's another possible scenario. Say I work at public health and I stopped up at the health agency HR to drop off my open enrollment papers, and on my way out I saw one of my neighbor's sons going into a drug and alcohol group room. When I saw my neighbor that weekend, I said I hope her son was staying on the wagon. She looked at me funny and said she didn't know what I was talking about. I immediately stopped talking about it. Did I do the right thing? The answer is no and yes. First, you violated your neighbor's son's rights by even mentioning what you saw to your neighbor. Remember, we can't even mention a person's participation or application for a program to anyone who does not have a need to know. But you did the right thing when you realized your error and said nothing more. This is important. While mentioning the son to your neighbor was a serious lapse of judgment, and it violated our policy and the law, you were correct to stop discussing the matter. Your response to the neighbor could simply be, I really can't talk about this work-related thing outside of the office. In this case, you must report this to your supervisor. Yes, you may receive some form of discipline for this breach, but failure to report an error of this type can be far worse than the improper disclosure itself. Because the penalties and risks to the county are so severe for not notifying clients of a breach, failure to self-report a breach is considered a very serious policy violation. Now let's talk about the rights these laws give to clients regarding their protected health records. While the laws we've discussed are generally considered to regulate privacy and security of client health information, HIPAA and other laws also give clients specific rights regarding control of their health information. The most common right is the right to receive a notice of privacy practices. Every client must be offered a notice of privacy practices at their first service delivery. This notice tells the client about other rights they have, and it also explains how we can use their health information. We ask all clients to sign a receipt indicating that they received a copy of this notice. The next most common right that a client exercises is the right to request and receive a copy of their health information or claims information. We generally honor all client requests for a copy of their records unless providing that information would prove harmful to them. There are several other rights granted clients, but they are generally exercised far less often. They include the right to request communication from their provider by the method of their choice. For example, they may only want to be called on their personal cell phone or may only want to receive communication via email because they don't want others to know that they're being treated. Other rights our clients have include the right to restrict how their health information may be disclosed. They have the right to an accounting of the disclosures of their health information. Because of this right, it's very important that employees log any disclosures of information in the client's file. It would be embarrassing and erode client confidence in us if a client had once requested a medical history be sent to their primary care physician but didn't see the disclosure listed in the accounting of disclosures they received. Clients also have a right to ask that health information be amended if they don't agree with its contents. Now, we're not required to comply. However, if we don't comply, the client does also have a right to include a statement of disagreement in their record. They have a right to submit a complaint to the HIPAA privacy officer if they believe their privacy has been violated, and they have the right to be notified if their PHI has been breached. As I said earlier, generally PHI can be used by the health agency for treatment, payment, or healthcare operations. However, a written authorization from the client is required for many uses and disclosures falling outside of treatment, payment, and operations. If the health agency needs to send information to another healthcare provider, we have an authorization form that the client can sign. Occasionally, another healthcare provider will present an authorization from the client requesting our records. If you receive an authorization form from another provider, it's important that no PHI be disclosed unless the authorization form is determined to be authentic and complete. Once an authorization is signed, a client has the right to revoke or cancel it at any time. Generally, only a custodian of records may disclose information requiring an authorization. Until you're trained on health agencies' policies and procedures regarding disclosure of PHI or other confidential information, you should request assistance from a supervisor. So what is a custodian of records? These are employees who've been specially trained and authorized to process complex health information disclosures. All of the health information technicians are considered custodians of record. In addition, the Drug and Alcohol Division has a designated custodian of record, as does the Public Health Department. While you as an employee may be allowed to use or disclose certain client health information as part of your job, only a custodian of records can disclose information that's restricted by a client authorization form. There are generally three types of disclosures: mandatory disclosures, permissive disclosures that do not require an authorization, and permissive disclosures that do require an authorization. Let's start with mandatory disclosures. In other words, disclosures that are required by law. These disclosures do not require an authorization and must be made even if the client objects. Mandatory disclosures include, for instance, when the client requests a copy of their own health information. We must give them a copy unless it would pose a threat to their health. We're also required to turn over PHI when asked to do so by the U.S. Department of Health and Human Services Office for Civil Rights Division. We must disclose PHI when necessary to report child abuse, elder abuse, or for Tarasoff safety warnings. And lastly, we're required to disclose PHI when directed to do so pursuant to a court order. Next, let's discuss permitted disclosures that don't require an authorization by the client. The health agency may disclose client health information without authorization for a number of reasons. The most common reason is for communication between qualified professionals who are directly involved in the medical or psychological care of the client. And these communications may include partner agencies such as TEMA and Family Care Network. We will also disclose PHI for payment and operation purposes as described earlier. Another reason we may disclose PHI without an authorization is when the client's having a bona fide medical emergency. We can disclose PHI to the treating emergency personnel for the purpose of caring for the client. For example, if a client were having a heart attack, we are permitted to tell the paramedics about current medications the client is taking. Generally, mandatory disclosures, uses for TPO purposes, you'll remember that's treatment, payment, and operations, and uses for a medical emergency are the only reasons we might disclose health information for a client of drug and alcohol services. With the exception of drug and alcohol health information, there are other permitted disclosures we may make. For example, we can disclose PHI pursuant to a subpoena. However, we generally attempt to secure a client's authorization even if it's not required. We can disclose PHI to avert a serious threat to health and safety, but only to the extent that it will help mitigate that threat. We can disclose limited amount of PHI to officers in a correctional institution related to an inmate so that the institution can maintain operations. We can disclose PHI to designated individuals at DSS or at the public guardian. And we can disclose PHI for public health activities. The important thing to remember is that you're permitted to make only those disclosures that are allowed in the policy and that your supervisor has authorized you to make. If you're unsure about whether you can disclose health information, be sure to ask your supervisor prior to making the disclosure. So we described mandatory disclosures, and we described permitted disclosures that don't require an authorization by the client. That leaves us permitted disclosures that do require an authorization by the client. The best way I can describe which uses and disclosures require a client authorization is to say that if it's not a mandatory disclosure, and it's not in our policy as a permitted disclosure without an authorization, then we must have a client authorization to disclose the health information. Again, if it's not a mandatory disclosure and it's not in our policy as a permitted disclosure without an authorization, then we can't disclose it without the client's authorization. For most employees, this distinction is not a real problem because they're only allowed to do certain mandatory disclosures and disclosures for TPO purposes. Remember, TPO being treatment, payment, and operations. With certain exceptions, only a custodian of records can disclose health information for purposes that require an authorization. Well, what can you as an individual disclose? Well, this depends on your job. Let's start with a reminder that unless you're a custodian of records, any use or disclosure must be limited to TPO within the health agency or disclosures mandated by law such as abuse or safety disclosures. The next 3 slides will address the differences between use and disclosure by qualified treatment professionals, individuals supporting treatment professionals, individuals performing payment and reimbursement duties or operations duties, and then all other employee rules. If you're a qualified treatment professional, for example, a therapist, drug and alcohol specialist, nutritionist, nurse, or doctor, you may discuss client PHI with other qualified treatment professionals or with support staff engaged in the treatment of the client. Generally, communications between qualified professionals is not restricted by the minimum necessary standard. However, communication with support staff must be limited to the minimum necessary for the purpose of the job. Of course, you'll always be expected to disclose for those reasons mandated by law, such as abuse or safety. If your role is to support treatment professionals, for example, if you're a drug and alcohol services aide, a mental health aide, a physical therapy aide, a patient services rep, or certain administrative assistants, you can discuss client PHI with treatment professionals or other support staff. Any communications must be restricted to the minimum necessary standard, though. If you're involved with payment, reimbursement, or healthcare operations, for example, if you're an accountant, administrative services officer, program manager, patient services rep, administrative assistant, or IT specialist, you may discuss client PHI with treatment professionals or other support employees to the extent that the communication is for the purposes of payment, reimbursement, or operations. Like those in support roles, any communication must be restricted to the minimum necessary standard. And lastly, if you're in a position where you have no access or very limited access to PHI, you must limit any access, use, or disclosure to purposes that you have been authorized and to the minimum necessary to achieve the task assigned. Now that we've discussed your role in the privacy of PHI, let's discuss your role in the security of PHI. Remember back at the beginning of this training, we distinguished the difference between privacy and security. I told you that security is best described as safeguarding confidential information in a way that prevents others from inappropriately accessing it or prevents unpermitted disclosures. Examples of this include locking your workstation whenever you step away, shredding confidential documents when they're no longer needed, and ensuring that others can't see confidential health information on your computer screen. Security of PHI is everyone's responsibility at the health agency. The HIPAA statute has a section dedicated to requirements for a covered entity to safeguard and secure PHI. These safeguards include technical, physical, and administrative safeguards that the health agency has adopted to ensure our PHI is safe and available for use. What do we mean by technical safeguards? Well, for example, every desktop and laptop computer owned by the health agency is encrypted. This means that if one were stolen, the data stored on the computer would be useless. What do we mean by physical safeguards? Well, an example would be ensuring that doors and file cabinets are locked and not accessible to those who should not have access to PHI. And what do we mean by administrative safeguards? Well, those would be policies such as controls on who has keys to buildings or how frequently training takes place. The law also requires the health agency to have a plan to ensure we can always access our clients' electronic PHI in case our servers are damaged or we can't access our buildings. Most employees already understand the common sense things we should do to safeguard a client's PHI. For example, we know that we must lock our computer when we leave it unattended for any period of time, and we know that we can't leave paper PHI just sitting around unattended. Most of these policies are common sense, but there are other policies that you may not be aware of. It's important that employees understand all of the health agency's security policies because only through compliance with all of the policies will we truly secure our client's PHI. In addition to understanding our policies, employees must also report when they believe security policies may have been violated or when they believe that the policy may not be effective. Because many of our security policies are technical in nature and don't apply to most employees, we have developed a special brochure that distills the key security policies that you as an employee need to know. This brochure can be found on the intranet, and it will also be provided to you annually for affirmation along with the countywide IT acceptable use policy. Let's talk about some of the most critical security safeguards. First, let's focus on computer safeguards. One of the most important safeguards you can control is to protect your passwords. Never share a password and never leave it written in a place where it can be found. This is one of the most common forms of breach, and when someone else has your password, any access looks as if it was you. Remember, every page you access on your computer is recorded by IT software and leaves a record of what you've accessed. You can control that access if you control your password. Don't load software without IT permission. Remember that breach at the Utah Department of Health? That was due to a malicious code that was uploaded when an employee loaded unauthorized software. Always get permission from IT before loading software. Position your computer screen to minimize the opportunities for others to see the PHI you have displayed. If this is not possible due to office configuration, contact IT so we can determine if a screen filter could help reduce that exposure. And always lock your computer before leaving it unattended, even briefly. Using the Windows key together with the L key is the easiest way to do that. Lastly, be sure your computer is set to automatically lock after no more than 10 minutes and preferably no more than 5 minutes of inactivity. Next, let's talk about securing PHI when transmitting by email. First, all of the email generated by health agency employees should have the health agency's confidentiality statement included. We understand that the statement may not apply to much of our communication. However, by keeping it as a default, you'll be protected if an email does contain protected information. Second, any email containing PHI must be limited to the minimum amount of information needed for the intended purpose of the communication. This way, if there is a breach, the damage may be minimized. In addition, if it's possible to send the information without any of the 18 identifiers we discussed earlier, the information is no longer protected. A way to do this is to remove any identifying information, send the email, then follow up with a phone call to share the identifying information with the recipient. The information is still protected health information because of the subsequent phone call, and all of the rules for disclosure still apply. However, by removing the identifying information from the email, you've safeguarded it during transmission. If you can't de-identify an email and you need to send PHI electronically, you must do so by sending it in an encrypted format. One thing to remember about email encryption is that the subject line of an email is not encrypted. Never put client identifying information in the subject of an email. If you don't have the ability to send an encrypted email, please see your supervisor for guidance. Often, we use fax machines to send PHI, or we use photocopiers to scan or copy paper PHI. When sending a fax, you must include a cover sheet with the health agency's confidentiality statement. In addition, it's very important that you verify the phone number of the fax recipient before you hit send. Transposed fax numbers are a common cause of PHI breach. A best practice is to voice call the recipient shortly after sending the fax and confirm that they've received the fax. This will ensure that you sent it to the correct fax number and will also prompt the recipient to pick up the document from their fax machine rather than leaving it exposed for others to see. Something that happens more commonly than we'd like to believe is when employees accidentally leave an original of PHI on a photocopier, scanner, or fax machine after imaging it. It's important that you retrieve both the original and copy of PHI from a photocopier or other device prior to leaving it. If you do accidentally leave an original or copy on a device and it's out of your control for any period of time, you must report this to your supervisor or the privacy officer. And lastly, no image of PHI may be made through any screen capture application, a camera, or a camera phone. These devices are not secure, and policy prohibits any imaging other than through county-owned scanners or photocopiers. The proliferation of portable computing devices and portable storage devices has changed the landscape of electronic security. These devices, which include laptops, tablets, smartphones, flash drives, cameras, and portable scanners, are now commonly used to communicate personal and business information. While these devices can be great tools, helping us do our job better, they also present the greatest risk in terms of information security. Some employees of the health agency have been authorized to use county-owned portable devices to do their job, and we have policies in place that govern the use of these devices. It's important to remember that no PHI may be stored on a portable device without written permission from health agency IT. If you've not been given a written notice allowing you to store PHI on a portable computing device, you may not do so, even if you are remoting in through the VPN network. Remember that accessing PHI through a portable device is permitted. For example, using the Persimmon application or Anasazi through a portable device is permitted as long as the data is not stored on the device. Generally, but not always, health agency IT will provide you with a county-owned device that's encrypted for safe access and storage of PHI. Another thing to remember is that you must maintain control of any portable device that accesses or stores PHI at all times. We talked earlier about the AvMed breach of 1.2 million client records. That breach was due to the theft of 2 laptops that employees had left unsecured. Laptop and tablet theft is the #1 reason for large-scale breaches. Besides laptops, tablets, and smartphones, you may have a need to save PHI on a portable storage device, such as a flash drive or thumb drive. Our policy is that you may only store health agency information on portable storage devices that have been issued to you by the health agency IT department. If needed for your job, they can issue you an encrypted flash drive. The bottom line is that we need to be particularly careful when using portable devices, and you may only do so when authorized in writing. Aside from the electronic security we all need to support, we also need to be sure that the physical environment we work in promotes information security as well. For example, it's important to be sure that computer equipment is not vulnerable to theft and is secure when not in use. Also, we need to be sure that the public does not have access to areas of our building where they just don't belong. Other common sense precautions include never leaving paper PHI unattended and be certain to lock it up when it's not in your control. And lastly, never throw paper PHI in the trash. It must be shredded or placed in a locked shredding bin. Other things employees must do to help secure our facilities and health information include immediately reporting a lost key or fob, not allowing anyone you don't know to enter a secure locked door behind you, ensuring that secure locked doors actually lock behind you, and immediately reporting anyone who is in the area of the building where they should not be. We've discussed the various laws and policies that help ensure our clients' health information remains private and secure. Now let's talk about your obligation to report to a supervisor or privacy officer when a violation, breach, or security problem occurs. The most important thing to know is that you're required to report any breach of PHI, violation of policy, or a security problem that you're aware of. You simply can't assume that someone else will report it or that no one will find out. It's everyone's responsibility to report a problem. As I said earlier, you must report a breach or violation even if you were the one who committed the breach or violation. Failure to report a breach or violation is a serious policy violation and can subject an employee to additional discipline. What are some of the breaches or violations that you must report? Here are a few examples. If you know an employee is sharing their password with others. If you find health agency PHI on someone's Facebook page. Or if you accidentally fax PHI to a wrong fax number. You also must report if you hear that an employee lost their laptop, or if you realize that you were discussing PHI and you think others who are not authorized may have heard. There are many other examples, but these give you a flavor for the types of things that are mandatory to report. You might be thinking, why is it so important for me to report a breach or violation? Well, first and foremost, the health agency wants to do the right thing. Reporting is the ethical thing to do. But beyond the ethical implications, it's important because the law says that we must compel employees to report violations or breaches. Those who wrote the laws understood that the best way to fix a problem is to know about it as soon as possible. As a frontline employee, you'll likely know about breaches or violations before we can find it in an audit or monitoring program, so we depend on you to report as soon as possible. And lastly, if we find a problem, fix it, and self-report the matter, the health agency will be at far less risk for serious penalties. So what are the consequences for a breach or violation? Well, each situation is different, and we can't say what would happen until we examine the specifics of that particular breach or violation. But generally, the Office for Civil Rights understands that penalties for accidental violations would be less than penalties for intentional violations. Self-reported violations would be less than found-out violations. First-time violations would be less than repeated violations, and inadvertent violations would be less than negligent violations. The Office for Civil Rights would apply these criteria to both the covered entity and the individual involved in any violations. As for employment discipline, we're governed by the civil service system, and we use a just cause test to determine the appropriate level of discipline. Most of the same principles that I just mentioned above are considered, and we generally approach discipline as an opportunity for individuals to correct and improve rather than simply as punishment. Who should you report a breach or violation to? Generally, you can report to any supervisor or manager, but you also may report a breach or violation to one of the designated privacy officers for the county. In behavioral health, the privacy officer is Kathy McGuire at extension 4863. In public health, the designated privacy officer is Jennifer Shea at extension 4773. You may also call me, Ken Tassif, at extension 4788 if you have any questions or need to report a violation or breach. Your supervisor or any of the privacy officers can also answer any questions you may have about privacy or security of client PHI. To wrap things up, here are a few concepts to remember. First, you need to be versed in the health agency policies regarding the use, disclosure, and security of PHI. These policies will give you good guidance on our standards for use and disclosures. Second, the concepts underlying health information privacy and security are fairly simple and common sense, but putting them to practice can be a bit more difficult. Let's face it, real life is always more complex than theory. You need to remember to ask questions if you're not sure about how to properly use or disclose PHI. Earlier in this training, I showed you where the policy is located on the health agency intranet. You must read and familiarize yourself with this policy. For all employees except for custodian of records, I recommend using the training version of the policy. We have also prepared a 4-page quick desk reference that you can keep at your desk. The document contains some basic principles, best practices, and contacts you can refer to if you have a question about health information privacy. Simply click on the link at the bottom of this page to access a copy. This document is also kept on the Compliance Intranet page. If you don't access the link at this time, you can always return to this page after the training is complete and access the link later. Our contract with the California Department of Health Care Services requires our employees to be trained annually on privacy and security of health information. This contract also requires all employees to sign acknowledgement of the training, which we do in the form of a confidentiality statement. Please click on the link below and the health agency's one-page confidentiality statement will open in another window. Please read this document. At the end of this slide, this window will close and you'll be taken back to the Relias Learning website where you'll see a web page that says your content has been launched in another window. On the right side of that web page is a button that says Next. You'll need to click on this button to complete the training by taking a one-question final exam. This final exam is simply a yes/no question asking if you completed the training, read the confidentiality statement, and agreed to abide by it. An affirmative response is required to get credit for this training, and all employees must agree to the terms of the confidentiality statement. Thank you for your commitment to protecting our clients' health information. As always, please feel free to call me if you have any questions at 781-4788. Again, when this window closes, please hit the button labeled Next to answer the question and complete the training. Thank you.